Welcome to the Probate Nation. Probate is a process to transfer the title or ownership of probate assets to the beneficiary of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. Our program today takes up a discussion about two types of personal injury claims that arise from time to time that the personal representative of a Maryland estate will need to evaluate and, if merited, pursue with litigation during the course of his probate journey. The first is personal injury to the decedent that arose prior to the decedent's death that did not cause his or her death. This is called a survival action or claim. The second is a personal injury that caused the death of the decedent, and this is called a wrongful death claim. Both claims are the estate may pursue, but as we will learn, while the beneficiary of each claim may be very different, the steps you will need to take are similar. We are pleased to have with us this evening two Maryland personal injury attorneys who provide insight and guidance as we investigate this topic and we'll learn what to do and when so that you properly lodge your claim and set the wheels in motion to pursue it. Our first guest is a partner in the Metro DC law firm Coons McKinney, where he represents plaintiffs in personal injury lawsuits in Maryland, DC, and Virginia. Prior to joining Coons McKinney, he worked for a regional law firm doing insurance defense work. He is a proud graduate of Gonzaga College High School, the University of Virginia, and George Mason School of Law. Our second guest is a partner with the Frederick, Maryland law firm of Horman Nichols, LLC, where his practice focuses on plaintiffs' personal injury and workmen's compensation. Prior to forming Horman Nichols in 2016, Andy was a partner with one of Baltimore's oldest insurance defense firms. He is a graduate of Andrews University and the University of Maryland School of Law. Please join me in welcoming attorneys Justin Beal and Andy Nichols. Fellas, thanks for coming by.
Thank you for having us.
A lot of talent on this podium right now. And I'm not talking about me, I'm talking about you gentlemen. Well, let's take a look at this and talk a little bit about this. JB, in the big picture, what type of personal injury lawsuits might a Maryland administrator, personal representative, need to pursue?
Well, there's two actually, Richard, and they're sort of combined in a way. They both arise out of the same nucleus or situation, which is unfortunately, the wrongful death of a family member or a resident of Maryland. Those two actions, the first one is a survival action, like you mentioned in your intro. And what that is that's the claim that the estate actually has. The second action is a wrongful death action, and that's brought by the beneficiaries, the family members of the decedent. What we normally see in our practice is those two cases brought together simultaneously and move forward through the litigation process in tandem.
Okay. And what is an example of a wrongful death claim that a state could sue on?
There's plenty of them. What we normally see are tractor-trailer accidents, med-mal cases, industrial accidents. Anytime when there's a negligence claim that's associated with a death, is when we generally pursue the wrongful death tandem plaintiff's case. Okay, and then what is an example of a survival action that an estate would sue on? Well, the survival action, again, is a little bit different than a wrongful death. The wrongful death is when the beneficiaries bring the claim, and then the survival action is an action that complements the wrongful death case, but that's brought by the estate itself. Okay. And that takes into consideration the claims that the decedent would have had. For instance, as an example, let's say that there's a decedent who's involved in a motor vehicle accident and is taken to a hospital where they survive for 10 days, 14 days, and then unfortunately they pass away. The medical bills in that particular situation is one of the damages that would be claimed under the survival action as opposed to the wrongful death action. Okay. So there are differences in what is claimed and what perspective is being claimed. But again, we normally see them brought at the same time simultaneously. Okay. And describe for me, briefly, the normal terms of engaging an attorney to represent the estate or the beneficiaries of the estate in a personal injury, survival action, or wrongful death claim. Sure. 3 points to that. The first one is, and this is a theme you're going to hear from Andy and I today, is you need to move quickly in these sorts of cases. And so as far as the documentation goes, you want to consult with an attorney quickly. I just want to get that out there initially. Number two, we would require a written fee agreement. That would lay out the terms of the representation on behalf of the beneficiaries, but also the estate. The terms of the agreement are usually 1/3 contingency fee.
Contingency fee.
And what that means is that the family or the estate does not pay out of pocket for the attorney's fees. It's a reimbursement of costs plus a percentage of whatever is recovered on behalf of the estate or the beneficiaries.
Okay.
So there's no cost to the actual family.
Okay. And I think we're going to get into who actually files the wrongful death action, Andy.
Generally, the wrongful death action is going to be filed by any beneficiary of the decedent. It can be a spouse, it can be a minor child, it can be a child that's no longer a minor if within the last 12 months they were receiving 50% or more financial support from the decedent. Those are generally the plaintiffs you'll see in a wrongful death case.
So unlike in Virginia where we have the administrator qualify in order to bring the claim, that really is not the case in Maryland. In Maryland, we actually have the individuals who would be seeking the recovery bring the claim.
Right, because Maryland carves out the two cases that Justin was just talking about, the survival action and the wrongful death.
Mm-hmm.
So because of the distinctions as to who has or who can maintain the cause of action, the wrongful death action is always maintained or brought directly by a beneficiary of the decedent.
Okay, very good. Now, what are the damages that are typically available in a wrongful death claim?
So the wrongful death claim damages can be both economic and non-economic. Now, the amount of damages that you might be able to recover in a wrongful death claim are going to be based on, there's a cap in Maryland statutorily for non-economic damages.
Okay, I knew you mentioned that when we were getting prepared for this program.
And in 2019, that applicable non-economic damages cap is $860,000.
Okay.
And that's a cap that resets October 1 of every year, and it goes up by, I believe, $15,000 per year. And so in a wrongful death case, each beneficiary up to two can get up to $860,000 in non-economic damages. Now, what that means is if there's 3 children, for example, minor children, the maximum that can be recovered on the non-economic damages side is going to be $860,000 times 2, even though there's 4 children.
Understood.
Now, the economic damages side, there is no cap on that. So, for example, a lot of times what they look at is the loss of future earning capacity of a spouse or a parent and the financial support that that beneficiary would have received had that person not been killed through the negligence of another party. Mm-hmm. And that damage has no limit to it. It's whatever damages you can present to a jury and that a jury accepts as being reasonable and related.
Okay, good to know. So who actually receives the monetary damages then?
So in a wrongful death case, the monetary damages, when the case goes to a jury, for example, will be broken down by each beneficiary, and the jury will make a determination how much they're going to give. And so the award itself will be awarded to the plaintiffs in the wrongful death case, which would be the beneficiary or beneficiaries that brought the case. Then, of course, once the jury award is collected, assuming it's collectible, then the accounting has to take place between the plaintiffs and their attorney just to make sure costs are reimbursed, like Justin touched on, as well as the attorney's fees are reimbursed. And sometimes, well, on the wrongful death side, there's no concern about liens or anything like you'll face potentially on a survival action if you're making a recovery for the actual medical bills that the decedent incurred before they passed away.
Okay. Okay. So the jury actually then decides how the monies are divided up then between the beneficiaries?
Because each beneficiary has his or her own separate claim.
So
and that's why.
Each one will make a presentation as, of course, of the litigation as to why they're entitled to whatever. And,
correct.
And the jury makes the final determination.
Right. And each and as a general rule with that, that's why there's that statutory restriction that you can only get that non-economic damages cap times 2, because you might have 4 or 5 beneficiaries, but the jury can't give out non-economic damages to each of them at that cap level. And the jury is not aware of the cap when they make the non-economic damages award.
So a lot of times you end up doing some sort of ratio then when you get done?
It can be. It can depend case to case, yeah.
Okay. Well, Justin, let's take a look at who files now. We're going to move to the survival action.
Sure.
Okay, so the survival lawsuit. Who actually files that?
Well, that's filed on behalf of the estate.
The
so
estate.
the estate would technically be the plaintiff. And in order to have an estate set up, You would want to consult with someone who does that professionally, and have the estate set up, have a personal representative appointed. Generally what we see spouses as personal representatives, children, parents, sometimes a family member, be the personal representative. That's sort of the mouthpiece of the estate, and that's the person who the plaintiffs deal with. But the estate technically is the plaintiff.
Okay. Now, what damages can the estate recover in a survival action like this?
It's generally non-economic damages. What we see a lot of the times are the pain and suffering from the point of injury to the time of death.
Okay.
There are also economic damages as well that can be recovered through a survival action. Medical bills, my example before, where somebody's in a hospital for a protracted period of time, they're going to incur medical bills, and those medical bills are going to have to be repaid more likely than not, depending on the arrangements, whether there's Medicare involved, whether there's, if it was a federal employee, there may be a lien, a federal employee lien, and so those can be collected as well through the survival action.
So, so let's talk for a second, because I know Andy mentioned this. There can be liens that can arise in this in the survival action that can impact the recovery.
Yes, there are. What a lien is generally is it's when another entity pays for medical bills, and then they understand that a claim has been made, and therefore they have an entitlement to be paid back a portion of what is recovered. For instance, the Medicare lien, those are promulgated by the federal government. Those are by statute, so we have to follow those rules.
Okay. Okay. Well, let's talk about, I think one of the big things we talked about during the preparation for this show is the investigation and lawsuit phase, as these things go through certain phases.
Absolutely.
So Justin, what information must be gathered to evaluate the merits of these two claims?
Sure, absolutely. Well, the first thing you want to do is find out what the source of death is. If it's a med mal case, then certain steps need to be taken. If it's a trucking accident, certain steps need to be taken. If it's an industrial accident, certain things need to be taken. For instance, if it's a med mal action, you definitely want to have an autopsy, and you want to have the medical records obtained as soon as possible. If it's a trucking accident, you definitely want to retain experts to go to the scene immediately and conduct their investigation from an expert perspective. The reason why is because timing is critical. People move away. People forget things as time progresses. There could be road marks. There could be evidence at the scene that goes away with time and with weather. And finally, with respect to an industrial accident, you'd want to do a FOIA request, maybe to a governmental investigating agency, such as an OSHA investigation or an OSHA report. So there are things that need to be done immediately, depending on what kind of accident we're dealing with here. One thing that's really important is if it was a tractor-trailer accident, for instance. Tractor-trailer engines, most of them are equipped with something called an ECM. It's an electronic control module. And so what that is it's the engine keeping track of statistics and mileage and braking speeds and distances. Sometimes what happens is the tractor-trailer engine will be damaged in an accident. And so the owner of the tractor trailer will be very anxious to, take care of the tractor trailer or dispose of it, and with it goes a black box or the ECM module. And so it's very important to get letters of preservation out to the appropriate entities to make sure that that electronic control module is not destroyed or sold or scrapped, and that the information can be extracted through experts. So that it can be used for the litigation if that's in fact the way it goes.
Well, that's good to know. I know you mentioned, I'm going to turn to Andy next, but I know we mentioned 911 calls get recorded, but those things get raced periodically, so we want to make sure we jump on that and get those procured and preserved as well, because it may be some important information on that.
That's right. My experience has been that each jurisdiction in Maryland has a different amount of time which they maintain and retain the 911 audio tapes. I've had many cases where I've found witnesses that I didn't know about and that weren't in police reports by getting the 911 tapes.
How interesting is that?
It is interesting because they'll leave their personal information and we'll be able to track them down that way. So
very interesting.
It's important to get that and retain that information.
Well, Andy, let's talk about the types of insurance coverage that might be available. As we begin to evaluate, we may have a great claim, but if there's no coverage, and no resource to pay, then it's hard for to really to justify bringing that lawsuit. So what are some of those insurance policies that you begin to look for?
Well, it's going to depend a lot on, again, something that Justin touched on earlier, which is what was the cause of death? You know,
Sure.
Was it an industrial accident? Was it a tractor-trailer accident, motor vehicle, or medical malpractice? So obviously within each of those areas there's different types of insurance coverage available. Personal automobiles by law are required in the state of Maryland to carry a minimum amount of insurance coverage, and then you also, if your underinsured motorist coverage is adequate enough, can file a claim against your own policy to collect certain portions of a judgment or settlement. There's also umbrella policies. A lot of people will have personal umbrella policies that may extend coverage into the millions. And then from the standpoint of tractor trailers, for example, oftentimes tractor trailer companies are self-insured, if not completely, up to a certain number. For example, some companies might be on the hook for the first million or 500,000 or whatever that number might be. They pay out of pocket, then they have an insurance company that underwrites them for anything in excess of that.
Okay.
And the same might apply with industrial loss, for example. There usually will be some sort of insurance policy in place that would offer indemnity in the case of a wrongful death or survival action.
Okay. Now, I do understand that there is a 3-year statute of limitations in order to bring these claims, so we do have to get on the stick about doing that. So, but let's talk for a second. You know, real quickly, JB, what are some of the common mistakes that are made by personal representatives when they're pursuing these types of claims?
The biggest one we see is
Briefly.
the biggest one we see is not moving quick enough.
Okay.
Sometimes what happens is we'll be contacted, a year after a death, and at that point, witnesses have disappeared and evidence has disappeared. 911 tapes have disappeared, ECMs have disappeared. So it's very important to move quickly, like I said initially. But another mistake that we see a lot of the times also is that the families don't communicate well, and this is a tough time for families, obviously. They're dealing with the loss of a loved one, and what we see sometimes is that transfers into sort of a fractured or a splintered family that we're dealt with. The point from our perspective is it's very difficult when there are multiple family members with multiple attorneys or multiple family members without attorneys, and some have attorneys. One of the mistakes that we see is that exact situation, and what we'd like to see is a unified family, if possible, with one attorney.
Okay. Now, I'm looking at our time for our thing, but I do know that we talked about the fact that clients a lot of times have unrealistic expectations. So one of the key things that I know both of you work on is to make sure we get those expectations and get them contained. We talked a little bit about the liens that can arise that will affect the recovery. So you might recover $1 million, but you have liens to pay before you get down to have anything left to actually divide. But let me just ask you, Andy. We hear a lot about mediation. Okay, talk a little bit about that and how that is a tool to help get case settled.
Sure. I think, and Justin would probably agree, most cases eventually resolve without having to go to trial. The percentage I don't know, but it's a very high percentage. And so, mediation requires that both or all sides, sometimes you might have multiple defendants or multiple plaintiffs, have to agree, we're going to sit down with a mediator. Could be a retired judge, could be an attorney, but it's someone that you generally want to make sure has knowledge about the area of law that you're litigating. Right. And essentially they are there to try and get each party to meet somewhere in the middle. And most mediators I know will tell you, I've done my job. If one side leaves, if each of you leave here a little bit unhappy, you got less than you wanted and you paid more than you wanted. But it really is a beneficial tool because it's cheaper for the parties because you're not having to deal with the cost of experts in moving forward with litigation. And it helps families get closure a lot sooner. When you go to trial, I say to clients, you understand if we go to trial and you have to testify, this may reopen a lot of hurtful memories you have, a lot of pain, having to deal almost with the loss of this loved one over again in some ways. And not only are you doing that, you're doing it in a courtroom full of strangers. And so it can be a very painful experience for clients. So I always advise my clients, let's try mediation and see if we can get this resolved without having to go that far down the road.
I think it's good advice. Well, Justin, let's talk about the judgment and settlement phase. In the case of in case there's a recovery by either judgment or settlement in a survival action, who actually receives the money? Just kind of walk me through that real quickly.
What would happen at that point is the estate would receive the money. and so it would have to go through the estate process to be dispersed. One interesting thing is that a sibling cannot recover through a wrongful death theory, but they may recover through a survival theory through the estate.
Okay.
So that's normally how we see that done, is through the estate.
Okay. And Andy, in the case of a wrongful death claim, if there's a recovery, judgment, or settlement, who actually receives the money?
That would be received and dispersed to each of the named plaintiffs in the case.
Okay, so whoever joined in that
Correct.
lawsuit, and then we would deal with that in that context among all the various parties and attorneys involved and all
Correct.
that stuff. Okay. Let's because I don't want to not have a chance to talk about some practical things which you guys can be kind of expansive about. Talk about some of the practical advice that you'd give families who have lost a loved one, due to a tragic event or an accident like that. So, Andy, just
Sure.
take a minute or two to talk about that.
I
some
think
practical
I would
advice.
reiterate some of the things Justin said, which is, it's a time of pain for a family, and it's a lot to have to deal with. Getting an attorney or law firm involved on the front end that is experienced with these types of cases is very important. As Justin talked about, the preservation of evidence is key, because that will really impact the strength of your case moving forward. So I think it's good to have an advocate early on in the case that knows what they're doing, that has experience with these cases, that can guide you through the process. And I think it's also good to have an attorney or a law firm that understands when it comes down to settling a case or resolving a case, what's the best way to structure that settlement or resolution to maximize the recovery for the family. Justin talked about liens, and if you have a Medicare or Medicaid lien, sometimes these settlements can be structured, and I don't mean structured like annuities, but I mean dispersed, where more money will go to the wrongful death side of the case than the survival side, meaning these governmental agencies or medical providers may have less money to recover from. That way it allows a family to recover more money to somehow try and compensate them for dealing with the death of a loved one.
Oh, interesting. That's a very interesting point. Well, I do know that these cases can be very, very challenging, especially when you get to the point where you want to settle it, and counsel may think it's appropriate to settle it, and then you have to deal with those expectations from the client, who may think, well, why are we settling this case?
Right.
So, Justin, how about yourself? Some practical advice or observations you want to share with folks?
Sure, absolutely. These situations are break your heart. From our standpoint, and you have to treat them with compassion, and you have to treat the decedent, who's your client, with respect, and you understand that the family is grieving. It's important to deliver the message in a compassionate way to the family that the money that's recovered, if there is money recovered, it doesn't replace the decedent, and that nothing can ever replace the decedent, but this is what's available to you under the law. And what we try to do is try to fight for every cent and every advantage that we can for our clients under the law. I think it's important to have that compassion for the family, but at the same time also we have a job to do.
And I think from what I gather too, it's important that people understand that it's important to get to an attorney early in these types of cases. Not just because there's a statute of limitations that may bar them from bringing the claim, but I think the most important thing is that getting that evidence preserved.
Yes.
That probably, I think, I take away from our conversation, it makes me get really nervous, when people say someone's just died, and then I start to ask those type of questions because of what we just talked about. So that's very good advice. I want to thank both of you for taking the time to come in and talk to us about this. I think it's very, very helpful, especially for relatives and for folks who have had a crisis like this where they've lost a loved one, that they understand that these are some key things they need to do. And it's a very helpful tool and great information, and it's a great public service that both of you have just provided.
Thank you.
Thank you for coming in.
Thanks for having us.
You're very welcome.
Appreciate it.
I want to thank our guests, again, for coming in and visiting with us today and sharing this very, really valuable information. Without a doubt, probate can be complicated and confusing, but as we learned in today's show, probating in the state of Maryland can involve more than just consolidating bank accounts, paying bills, filing tax returns, and reporting all of that to the local register of wills. In fact, sometimes the only work a personal representative may have to do is to pursue a claim by the estate or family members for damages arising from a personal injury claim, whether a survival action or wrongful death claim. As we learned from our guests, sorting out the facts of a potential claim is best done as soon as possible with a personal injury attorney who can help you understand the merits of a claim and how best to proceed to build and pursue that claim in a timely manner. And of course, remember, it costs you nothing to get that advice at the outset. We urge you to heed this advice. This brings us to the conclusion of our show on Maryland wrongful death and survival claims. We hope you found the discussion today helpful. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.